Hi guys, welcome to the Lawstril, Awesomely Awesome Lawyers. So I am here to present the series of lectures on Constitution of India or Constitutional Law. This is the second lecture of this introduction to Constitution of India. This series is presented and conceptualized by me. My name is Shreya Deshpande. I am a law graduate. In the last video, I have covered the concept of dharma and evidences as to the different forms of republican government and evidences of such forms in history, records by scholar Megasthenes and position of the king, that is constitutional monarch, British rule, formation of East India Company, royal charter, establishment of trading centers and presidency towns, charter of 1669, charter of 1726, charter of 1863 and the emergence of the company as the dominant power. Now let's begin with the further part. Regulating Act of 1773. The 1773 Act is particularly important in India's constitutional history inasmuch as it was the beginning of the efforts of the British parliamentary control over the company administration in India. The administration of territories under the company rule was no more a private affair of the traders of the company. The Regulating Act of 1773 for the first time presented a charter which was written for the company rule in India and acknowledged the political and administrative responsibilities of the company. The Act was also perhaps the first step in the direction of consolidation of British rule and centralization of administration in India. The Act established a Supreme Court at Calcutta, brought the three erstwhile independent and separate presidencies generally under the control of the Governor General of Bengal with his four newly appointed councillors, and brought about fundamental reforms in the composition of the Court of Directors in England. Pitt's India Act. The 1773 Act suffered from several shortcomings in the matter of practical operation. The Amending Act of 1781 tried to remedy these. However, the next major act was the Pitt's India Act of 1784. Under this act, the East India Company's Court of Directors were left with the responsibilities in matters of trade and commerce only, while for the political matters the British government appointed a board of control for 6 members. This board was empowered to superintend, direct and control all operations of the civil and military government of British possessions in India. Then the Charter Acts of 1793 and 1813. The Charter Acts of 1793 and 1813 renewed the company's charter each time for the further period of 20 years. The 1813 Act, however, deprived the company of the monopoly trade in India, while the powers of the three councils of Madras, Bombay and Calcutta were enlarged, and they were also subjected to greater control of the British Parliament. So all regulations made by the three councils were thereafter required to be laid before the Parliament. The Charter Act of 1833. The first faint beginnings of the constitution making during the British rule in India are to be found in the Charter Act of 1833. This act introduced an element of institutional specialization in the government of the British territories in India by differentiating the law-making meetings of the Governor-General in Council from its executive meetings. The superintendence, direction and control of the whole civil and military government of all the British territories and revenues in India was expressly vested in the Governor-General of India in Council. So for the first time, the Governor-General's government was known as the Government in India or Government of India and his council as the Indian Council. The Act introduced centralization in the legislative sphere as well. The council was enlarged for the legislative work by addition of a law member in addition to the existing 3. The Governor-General of India in Council was now vested, subject to certain restrictions, with the exclusive power of legislation for the whole of the British territories in India. Then the Charter Act of 1853. The last of the Charter Acts, the Charter Act of 1853, made the important changes in the machinery for the Indian legislation. Though the Governor-General's Council was continued as the one legislative authority competent to enact laws for the whole of the British India, so many alterations were made in its character and composition that the system was entirely changed. The council was enlarged for the legislative purposes by the addition of 6 special members who were expressly debarred from sitting and voting in the council, except at the meetings thereof for making laws and regulations. These members were called legislative councillors. The council now consisted of 12 members, including the Governor General, the Commander-in-Chief, 4 representatives of the local governments of Madras, Bombay, Calcutta and Agra. The legislative functions of the councils were clearly demarcated from its executive functions. The special nature emphasized by the express requirements of Section 23 of the Act that the powers of making laws or regulations vested in the Governor General in Council were to be exercised only at the meetings of the said Council. So this is how the Charter Act of 1853 formed and functioned. Then the Act of 1858. The revolt of 1857 is described as the Indian Mutiny by the British historians and as the first war of independence by the Indians, was the first organized attempt to overthrow the British rule in India after it was firmly established. The revolt, which was eventually suppressed, gave a death blow to the system of East India Company's rule in India. A new act was passed by the British Parliament after much discussion of the principles which should form the basis of a new policy. This act finally became the Act for the Good Government of India of 1858. Under this act, all the Indian territories then in the possession of the company became vested in the Crown and were to be governed directly by and in the name of the Crown, acting through a Principal Secretary of State for India. The Act of 1853 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be superintended and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. So whatever the system came into India or whatever it was introduced, it was nothing new to the Indians. Then the Indian Councils Act of 1861. Soon after it was deemed necessary by the government to initiate a policy reform of the Indian administration and to consider ways and means of establishing closer contacts with the public opinion in the country and taking non-officials, both European and Indian, into the council of the government, with a view to obtaining timely expression of the feelings and sentiments of the members of outside public concerning measures proposed to be taken by the government. So this was the very first time when the Indians were also introduced to this system. The Indian Councils Act of 1861 is an important landmark in the constitutional history of India. It is important for two main reasons. First is it enabled the Governor General to associate representatives of the Indian people with the work of legislation by nominating them to his expanded council, and secondly, it decentralized the legislative powers of the Governor General's council and vested them in the governments of Bombay and Madras. The Executive Council of the Governor General was enlarged by the addition of a fifth member who was to be a jurist, and for the purposes of legislation by the addition of not less than 6 and not more than 12 additional members, at least half of whom were to be non-officials. Although not expressly provided for in the Act, the non-official element of the Legislative Council could include Indians. So it was not actually expressly provided in the Act, yet the Indians were included in the Legislative Council. Actually, in 1862, the Governor General Lord Canning appointed 3 Indians, that is the Maharaja of Patiala, the Raja of Banaras and Sir Dinkar Rao, to the newly constituted Legislative Council. For the first time since the beginning of the British rule in India, Indians were being associated with the work of legislation. The 1861 Act suffered from many defects. Also, it did not satisfy the aspirations of the Indians. It made the Governor General all powerful. The non-official members could hardly play any effective role. No questions could be discussed or asked, and the budget could not be discussed. The political and economic situation in the country steadily deteriorated. There was acute scarcity of food grains and a severe famine in 1877. The discontent was widespread and the situation was explosive. The repression that followed the 1857 revolt had created a strong feeling against the British. Later, in the next video, I will be covering the part of birth of Indian National Congress and then the various reforms. So, I hope you guys enjoyed watching this video. Thank you for watching this video. Watch more videos of this series for better understanding of the subject. Please do like, share and subscribe for more awesomely awesome videos to our channel. And for more updates, stay connected to our Facebook page, that is www.facebook.com/lawsomelyloster. Please feel free to comment in the comment section below if you have any doubts or queries and even for suggestions. Thanks for watching.